Hello, this is Eva the Elfpire, and on today's video, we're going to go through a court document that just appeared in the Sarah Boone case, and it is a defendant's motion for a new trial. So, like, comment, subscribe, headbutt the notification bell as hard as you possibly can, and let's get into it. So, in this defendant's motion comes now the defendant Sarah Boone by and through counsel and pursuant to Rule 3.600 Florida Rules of Criminal Procedure files this motion for new trial stating in support thereof the following. The defendant was found guilty as charged of second-degree murder on October 25th, 2024. The instant motion is timely filed pursuant to Rule 3.600 and the defendant asserts that she is entitled to a new trial under Rule 3.600 on the following grounds. 1. The court erred in ruling that the defendant was not entitled to court-appointed counsel. 2. The court erred in denying undesired counsel's multiple motions for continuance. 3. The court erred in failing to grant a new trial when the alleged victim's family caused an emotional outburst in open court in the presence of the jury prior to deliberations. 5. The trial court failed to... 4. The trial court failed to disallow the opinion testimony of the state's rebuttal expert witness, Dr. Tona Werner, MD, after the state failed to disclose before trial that the witness had formed a new opinion. That was a minor discovery violation that we witnessed on Legal Mindset stream. And number 5, the state's committed prosecutorial misconduct by essentially making a second argument instead of a rebuttal argument. Okay, so this is going to be interesting. So we're going to address the first one. Of course, the trial court erred in holding the defendant was not entitled to court-appointed counsel. In the above styled and numbered cases, the defendant had approximately 7 court-appointed attorneys. Prior to this was 8, by the way, not 7. Don't know why he can't get numbers right. Owens never can get numbers right, I've noticed that. Let's see here. Prior to undersigned counsel taking her case. Undersigned counsel took on the above case because he was concerned that Miss Boone would not have an attorney to represent her at trial. The above case was very complex. It wasn't. Even for a seasoned trial attorney who was a public defender of the First Judicial Circuit for years, as well as having a thriving private practice. I don't know how thriving your practice is going to be after this, Owens. It was apparent to understand trial counsel that Miss Boone would be grossly ill-prepared and unequipped to handle a trial in this matter, or in fact to handle any other phase of the trial without counsel. Both the Sixth Amendment as well as Rule 3.111, Florida Rules of Criminal Procedure, guarantee an indignant defendant the right to appointed counsel. See Boone v. State, 150, all bunch of case law, which is true. It is true that you're guaranteed you can get a court-appointed attorney if you can't afford one. The problem is she went through 8 of them, and on the 8th one she was told specifically, this is your last shot. It might be rare, but the judge is allowed to take away your right to an attorney if you abuse it, as Sarah Boone had. Let's see here. And the defendant physically harms or threatens to harm, okay, this is all... Yeah, no, okay, so, basically that's all just case law being quoted and stuff. I'm not going to go through all of that. I just went through the reasons why they were denied court-appointed counsel. It was due to their own actions, misbehavior, and trying to solicit illegal motions, legal activity from their appointment counsel. It's stupid. Okay, let's see here. Argument 2. The court erred in failing to grant defendant's motions for continuance made by undersigned trial counsel. So, this is funny. He's saying that he doesn't have enough time. He didn't have enough time to properly prepare for the trial. The problem is, upon taking the case, the judge warned him. Wasn't getting any extra time, and it's on you. He agreed to those terms, so him trying to get a new trial based on that is absolutely ridiculous. He has continuously made these continuance motions, and he has been pretty regularly denied them. So, the court shall not deprive the defendant of his or her right to counsel of their choice. Wait, what? Failure of the trial court to grant a continuance will result in a new trial should the court deny said motion for continuance by new counsel. See, okay, yeah, whatever. Again, he was warned. He should know better. Argument 3. The court erred when it denied a motion for new trial due to an emotional outburst in the presence of the jury. I remember this specifically in Legal Mindset stream, and I'll see if I can get a clip right here.
Okay, may proceed.
Oh, they're gonna. This motherfucker interrupted that by saying it's too loud. What a bitch, trying to interrupt their best evidence. You know what they should do? Rewind it and play it again. Fuck you, Owen. You're not supposed to be able to object on closing. It's a rare thing. And of course, they found a way. Oh, I guess they didn't want to watch. They couldn't watch.
Okay, may proceed.
Oh, they're gonna.
I think that right's been compromised.
Oh, he's gonna try to make a motion
Who's scheduled for two detectives on the front row
for mistrial.
Family and victim. But they had to have known to tell them that the suitcase video, which has been around for 4.5 years, was going to be played during opening statement. And the state attorney's office or the sheriff's department had to advise them, or the victim.
He's trying to move for. He's gonna motion for a mistrial.
That if they couldn't take it in front of a jury,
Based on the mom crying.
they needed to get out of the courtroom. Now, what happened here today should not ever happen. There should be safeguards in place. There's no room for this after 2 weeks of murder trial for something like that to happen.
He's objecting to
One
the
of
mom
members
crying.
of the family audibly during the 2 minutes.
This is a
suitcase
Hail
video
Mary.
expressed some kind of emotional reaction. I look back, he or she were bent over in agony, physical pain.
This guy's a fucking piece of shit.
The physical pain followed the audible announcement.
Yeah, I'm
can't unring that
disgusted
bell.
with Owens.
That's their responsibility to ensure that kind of thing doesn't happen.
Just because Sarah Boone doesn't have any fucking emotions doesn't mean other people have to live that life.
And especially when they know they're going to show a video and the family of the victim is on the front row. I've never heard of such. I asked for a mistrial.
Response.
I've never heard of such a request. The victim's family has the right to be here. They were advised as to what will be used during closing arguments. I cannot make a decision for the victim's family and the homicide survivors as to whether or not
They'd have rights to be there, yep.
she clearly, or he, I don't know, couldn't, and I believe the appropriate thing was done. They left the court. But again, to say this is intentional sabotage and all the accusations that continuously get made are unsubstantiated. And it does not warrant a mistrial. People get warned, and sometimes they misjudge their own emotions. I don't understand what test we are expected to run on homicide survivors. So the motion should be denied.
Motion's denied.
It's the suck it all.
So the emotional outburst was extremely light. The mom, I believe, put her head down, hit her head, and then quickly exited the courtroom. It was very minor. The jury was sent out. They were told to disregard it, and it was more or less dealt with. But Owens pitched a fit about this too in court, and it was, I imagine, the cause for many of the sidebars that we saw during that time. Argument 4. The court erred in allowing the opinion of the state's expert not previously disclosed. Okay, so I think this is the minor discovery violation that they were talking about, and this was also Owens' fault because Owen said, as a question to the person in the deposition, Miss Dr. Tonia Werner, said, "Is there any opinions that you might share?" and was extremely broad on the question. She specified that if someone asks me a question about specifics, I will be able to answer it, but that's too broad of a question. So he got mad at her for being too broad with her answer when he was the one who was too broad with his question. Then the judge actually allowed a impromptu deposition to happen right there, oversaw by him, and Owens was still fumbling, and it was just a delay tactic. It was absolutely ridiculous. So no, I don't agree with that argument either. That leads us to the last final argument here. The prosecutor committed misconduct by using rebuttal argument to make a second closing argument. The state committed prosecutorial misconduct by essentially making a second closing argument instead of a rebuttal argument. Counsel for the state made a second closing argument posed as a rebuttal. Wherefore, premises consider the defendant seeks a relief sought herein, as well as any relief to which he may be entitled. The defendant requests a hearing in this matter. Ah, Jesus. Argument 5 doesn't make a lot of sense to me. I think their rebuttal argument was a proper rebuttal. I'm not sure why they're saying that it's not. But, alright. Anyway, this is, this was done 4th of November, 2024, so just a few days ago. I don't see this getting anywhere. It's probably going to be laughed out of court, although the judge here does not laugh. He's a very serious and very conscientious of the decisions he was making. In fact, there were a couple calls that he made that, while we understood, I just couldn't necessarily agree with. He was being overly cautious about appeal. So these are going to be denied. They've been denied multiple times. They were denied during the trial, and I don't see any reason why they would grant them now. So that's the update here. It's not a very big one. We'll probably have another one on the sentencing hearing on December 2nd. But until then, again, like, comment, and subscribe if you like this content, and I'll catch you on the next one.